How can someone protect themselves in the event of a breakdown in a nikah marriage? And in your experience, how have you successfully resolved situations like this? Could you share a real life example?
Look, the first thing that needs to happen is they need to understand that the relationship is a cohabitee style relationship. So what I mean by that is essentially it's like being a boyfriend and girlfriend. Um, Regardless of what label you put on it, the law would say that they were essentially cohabiting. Now, in those situations, if you're feeling that the relationship is coming towards the end, what you need to do is you need to start looking at how the law is going to interpret any assets or how it's going to split assets. So, what you need to start doing is, first of all, I mean, being a lawyer, is speak to a lawyer and get some advice as to do I have any rights and how do I protect my rights? But the very first thing that you need to do is you need to start gathering evidence, establishing a narrative of what your intentions of each asset were. So, for example, you might have a house. The house might be in the name of your nikah husband, and you, as a working partner, were contributing towards that property. You need to understand what your intention of that contribution was. Was it a contribution because I'm living there? Is it living expenses? But was it a contribution towards the mortgage? If it was a contribution towards the mortgage, what was your intention of that contribution? Were you intending to own the property? If you were, then what we need to do is we need to start looking at whether a trust has been created. And if a trust has been created, do you have ownership? And if you have ownership, did the other party intend to give you a share of that property? So these are things that you need to really start strategizing on. The moment you see that this relationship is breaking down, you need to start gathering evidence, creating a narrative that this is what our intention with this particular asset was. Because a lot of the time, what I see and real life case examples is you've got two very successful people who've probably met at university. Both of them have lived together for a number of years, since the early 20s. They're both professionals. One is the male, and typically he then goes on to become more successful. The female has children. They've had this nikah during their 20s, and all of a sudden in their 30s, late 30s, early 40s, they are thinking, well, this relationship isn't working because we were very young when we started. And in those circumstances, the male has generated a significant amount of assets and not himself. Both of them have contributed, but everything is in his sole name. He has done that quite strategically because he's thinking, I've got nikah only. She's not going to walk away with 50%. But what we can do in those circumstances is start looking at what the intention of the parties were. So even though legally one party holds the asset, the other may have a beneficial interest in that particular asset because of the intentions of the parties. So we need to start looking at what the intention is behind each asset. So it's very important that what happens is early on you start gathering evidence of what the intentions were. That could be text messages, that could be conversations that were had, because when we do start looking at the Trust of Land Appointment of Trustees Act and bringing a claim, the question that's going to be asked of the individual who's bringing the claim is what the intention was and what conversations were had and what led to them believing that they would have some ownership of that particular asset.